Called to order. It is Tuesday, May 5th, 2026. Madam Secretary, can you call the roll, please?
Chairwoman Johnson,
Present.
Vice Chairman Bishop,
Present.
Member Becker, Member Connors,
Present.
Member Jekyll,
Present.
Member Rhoda, Member Schultz, Executive Director Melanian,
Present.
Liaison Person.
Present.
Thank you. Agenda item number 1, the board may discuss and vote to approve the minutes of the meeting of April 7th, 2026. We've received the minutes. I trust you've had a chance to review. If so, can I have a motion to approve?
Second.
Moved and seconded to approve the minutes. All in favor signify by saying aye.
Aye. I'll abstain.
I'll abstain as well because I was not here. Agenda item number 2, the board may hear proposed legislation presented by the Office of the Secretary of State for submission to the General Assembly for the 2026 legislative session. The proposed legislation is attached to the agenda. And I think we have Rob and Kathy here to present. Give me that.
Hi, good afternoon,
Good afternoon.
Chair and members of the committee. How are you? I decided to bring Rob along with me today. So the purpose of this Rhode Island Voting Rights Act, House Bill 8334, Senate 3143, is to codify the protections in the Federal Voting Rights Act to ensure Rhode Island's elections are fair and accessible. Since 2023, the federal courts have repeatedly diminished the Federal Voting Rights Act, and last week's United States Supreme Court decision is proof of how our federal institutions are undermining provisions that have been in place for decades, meant to protect racial minorities' access to voting and selecting the candidates of their choosing. The Rhode Island VRA would codify protections against voter suppression and vote dilution at the state level. Voter suppression is the discrimination that limits a voter's access to voting opportunities or participation in any part of the political process. And vote dilution is the drawing of voting districts that weaken or cancel out the voting strength of racial minorities. In addition, this legislation provides protections for voters covered under Section 203 requiring language access. For example, voting materials, forms, assistance to voters in a covered jurisdiction, which we have 4 right now in Rhode Island, Central Falls, Pawtucket, Providence, and Woonsocket. And in 2024, the Department of Justice entered into a consent decree with the city of Pawtucket to resolve violations of the VRA and HAVA regarding Spanish language assistance because Pawtucket did not provide bilingual documents required under Section 203 under the Voting Rights Act. Also, the Rhode Island VRA provides protections for voters and with disabilities, accessible parking, polling place, and voting equipment. And this legislation protects voters from intimidation and harassment when casting a ballot or accessing the polls. So to enforce these provisions, the Rhode Island VRA permits individuals or groups, as well as the Attorney General, to bring legal action against any jurisdiction that subjects voters to suppressive voting tactics or dilutes the power of their vote. Specifically, it would hold the Board of Canvassers, Department of State, and the Board of Elections accountable to remedy voter suppression and vote dilution claims. And just as an FYI, the Rhode Island City and Town Clerks Association voted unanimously to support this legislation. Thank you.
Thank you, Kathy. Open it up for questions at this time. Sir?
Thanks. For the purposes of definition, how would you define vote dilution? I didn't notice it defined in the definition section,
yeah.
so I'm just not aware of how to define
Yeah,
it.
so vote dilution would be if a racial minority was split between 2 districts so as to not be able to elect someone that they prefer, a candidate they prefer. So if you've got a majority-minority district that is now split between 2 districts, lessening the ability for that racial minority to elect a candidate of their choosing.
Okay, thank you.
So it's related to the redistricting.
Okay.
Vote dilution.
So I have a number of questions, and I want to thank the Deputy Secretary of State who spent some time, several phone calls with me to answer some of my questions and get back to me. on questions I had. So I appreciate your time, Mr. Deputy, for doing that. So just some questions that there's certainly, looking at this, there's certainly things in here that I think are fine. I think some of the things that you mentioned, Kathy, just talking about, like voter intimidation, things that we already have that are existing law that are hopefully are prevented and not actually happening. But I have some specific questions about specific sections. Page 4. And Rob and I did discuss all these, so I apologize. We're going over some of these again, but page 4, section 3 reads, a violation of this section may also be established through direct or circumstantial evidence. My concern, I have several general concerns, but my general concern here is that we're opening up quite a large legal surface for cities and towns to be, have suits brought against them. And I think there's an underlying assumption here that if certain actions happen, it's because somebody is trying to discriminate in a negative way against a protected class. And so I think that's one of the things that concerns me. So I had a question starting about the circumstantial evidence, like what would be an example of circumstantial? Obviously, direct evidence is clear, but circumstantial is a lower legal bar. And again, I'll just say I'm not an attorney, but I know it's a lower legal bar. So
Yeah.
can you talk about that, Rob?
Yeah, and I think I would ask for the assistance of the lawyers about circumstantial. The way I understand it is that if it's something that might not be, or something that's circumstantial would be, there's no intentional discrimination, but it just so happens to be that way. So if there was a neighborhood that was split between two districts because of population, for example, that's a legitimate reason to split a district. However, if it also the unintended consequence of splitting that neighborhood also then potentially dilutes a racial minority's vote, then that would be to a judge. I think you'd have to prove that it's circumstantial evidence to say that there was discrimination. So you're right, it's not direct, but it would lead the court to say there's no other way to look at this but discrimination. And it might not be intentional, it might not be malicious, it might just be they were trying to check every box they could to make sure that there was enough people in every district. And unfortunately, there was vote dilution. So that's what would be brought before the court. And the court would decide if that circumstantial evidence would be enough to indicate that lines were drawn in a discriminating fashion. And Ray,
No, I can't add much more to that. I mean, the trier of fact would be looking to the consequences of the act as opposed to the intent of the act. That would be the key difference, both from the decision that just came out from the U.S. Supreme Court on Calais, which, focuses on you have to have an intent to discriminate before that would be factored in, versus looking at the consequences, which could be circumstantial evidence. It may not be direct evidence, but the circumstances by a preponderance of that evidence may be sufficient to show that the interests of the minority voters are being adversely affected or being diluted by the policy, by the actions that have been taken by the state, by other government agency.
Thank you. No, I appreciate the clarification. My concern with that particular language is that the calculus to get there is very complicated, and it's not objective. There's a lot of subjectivity in there, and there's a lack of objectivity. I don't know. We don't know who's going to be making that decision. Obviously, probably a court of some sort is going to be making that decision, and how they're going to arrive at that. So the use of that, again, I think it opens up the opportunity for cities and towns to be at the receiving end of a lot of legal action. I personally, when I was on the board of canvassers in Cranston, went through a redistricting commission after the 2000 census, and I can say, our guiding principle was basically we tried to follow neighborhoods and natural barriers. We didn't necessarily look at where particular protected class groups were or lived. So in a way, so the outcome may have been with the ward or Senate or the House districts in Cranston may have been that we unintentionally split, but I certainly don't think it's odd to me that we think the default I can tell you that was not our intention. If that did happen, I don't think, maybe it didn't, but if the default is to assume that there's some sort of negative discrimination going on, then that makes me uncomfortable, I guess, with that particular portion of it. So,
And just Commissioner, on that, the 8 states, I think Maryland just passed one, but I'm going to, just this week, I think, but the 8 states that previously passed Voting Rights Acts
Mhm.
have not seen a flurry of litigation to this point. And some of them have had their Voter Rights Acts for several years now.
yeah,
So just other states haven't seen the additional lawsuits.
Oh, that's
Because I
good.
think that when lines are, we're talking about redistricting, when lines are drawn, this has been a factor for decades. We're just want to make sure that no matter what happens at the federal level, we're okay here in Rhode Island. And so I
Yeah.
think that this is normal for how the districts have been drawn. And I think that even in Cranston, should there have been unintentional consequences, I think that there still should be the ability for a group to say, hey, Cranston, these lines are not drawn properly, even though it was
Yeah.
unintentional.
That's fair. I appreciate that information. I think one of the things that I think an example, the Supreme Court case itself shows how complicated this issue can be, because I didn't read the decision, but knowing the circumstances of the case in a basic level, so I know this was Louisiana. They started with one majority minority district. Then one court said, no, you have to have 2. They added the second. Then a separate court said, no, you don't have to have the second. And that's why it's very complicated. It's just, I think it's right for, and then it went all the way to the Supreme Court. So that is my worry, that we're opening up. And I know this has somewhat been in place because of the federal Voting Rights Act, but that's, one of my areas of concern. On the next page, page 5 of 17, I'll make sure I'm in the right section. Section 2, subsection I. Racially polarized voting must be assessed based on relevant election results, which may include but not limited to elections for offices in the political subdivision. That goes on from there. Can you provide some
Yes. So
background on that one?
page 5, lines 17 through 20.
Yeah, 17 to 20, yeah,
Yep,
sorry.
okay. So this is to determine protected classes and racially profiled voting. There is, you say, there's a lot of data that gets reviewed to determine racially polarized voting. So they're going to look at previous election results for different offices. And obviously with a secret ballot, we never know for sure who
Mhm.
someone votes for. But looking at census data and prior election results gives the folks who are drawing lines the ability to determine if there's a protected class in a specific area. So there's a swath of data that's being looked at by redistricting folks, census folks, that will provide that's how the racially polarized voting is assessed, using that data to determine whether or not a protected class is existing in an area.
So, I mean, political common sense would tell us that if an area has generally voted a certain way, that going forward, it probably will vote a certain way. But occasionally changes have happened, like different groups have even shifted even a small amount, even in the past several elections. So how would we, I guess my issue here, we're looking at that is and I think this, by looking at this from both political sides of the aisle, I've seen like people on both political sides of the aisle like this, because it might put one particular protected class group in a district that makes it safe. It's safe for that party. And then the other party may say, well, I don't have to worry about that. So I think the problem one of the problems with drawing the districts basically just on the protected class is that you're almost forcing a situation where you're not forcing every candidate to work for or with all the different groups that could potentially be in their area. So we're literally putting certain classes in one area and then saying, okay, well, they're safe for one party and the other party can ignore them. I don't think going forward this is just a philosophical situation, but that's not a way that, we're going to solve problems, in my opinion. So I think doing that allows parties to operate in a certain way that I think has been detrimental. Going further down, Rob, the 28 and 29, lower high turnout and the registration rates among a protected class members does not preclude the finding of racially polarized voting. So if in a particular election, a protected class has a low turnout, that, which is beyond the control of, I would imagine, whoever is drawing the lines, unless they've engaged in very specific behavior. But they're going to be held accountable to that. How do they control that?
So when looking at vote dilution, it's all based on the actual lines being drawn before the election. So the point of that section is that no matter what happens in the election itself, it's based on the lines that are drawn. So if you have a majority minority district, but no minority candidate running, clearly a minority candidate can't win. So it has nothing to do with the results or the turnout or the registration. It has to do with how the lines are drawn and making sure that vote dilution is not present by splitting a racial minority.
Yeah.
So it has nothing to do with an election going forward. It's using data from previous elections and who's living in a specific area to determine or to make sure that lines are not just drawn in a discriminating way, no matter what happens in the election, because the lines are the most important to make sure that everybody has a fair shot.
So-
Not if certain folks don't vote or certain candidates don't win, that's not the point. It's making sure that the lines are drawn so that there's fairness.
So, but if there's low turnout in a particular, somebody could come back and say, well, like after the election and say it's because of the lines. But you're saying that's not what this is intended to do.
Correct.
This is intended to be before the election happens. But I don't understand, why would we need this section then? If low turnout is not important because we're looking at past elections, then why would you need this language?
I think it's important to note that this is not about who wins an election. It's about I think it's just trying to make clear that it doesn't matter about the turnout or the results. It has to do with before the election, how those lines were drawn.
Mhm. Okay. You've mentioned the word fair on a few times. I think people could disagree. Well-meaning people on both from all over could disagree to say that a certain outcome of a redistricting is fair, but that's kind of based on your viewpoint. So I think again that's another thing that's not objective. That's subjective. And again, that's something that makes me concerned about this particular bill, the way it's written now. And the next page 6, line 20, starting in 23.
You say 23, Commissioner?
Yes. I'm sorry, I'm looking, I didn't
Just
fully
the
highlight
pre-approval?
this section. Yeah, this is just about the pre-approval, and the deputy and I had a long conversation about this. Well, my concern here is that you're almost turning the courts into a legislature, doing the legislative action, because now they have to approve it. And I don't want to speak for Rob, but he did make the good point that in Rhode Island, because it's a 10-year window, in Rhode Island, that really means one election or one redistricting rather, because we're doing it after the census. But I'm not comfortable with that. Like that to me does not belong in the courts, although I understand that might be an outcome of a particular case that came up. I don't want to misrepresent what you said to me, Rob, so.
Yep. So this section is to ensure that if there's an organization, whether it's the Board of Elections or the Secretary of State, or generally, I guess it would be cities and towns with redistricting, if there's a history and they have violated a voter discrimination or a vote dilution procedure in the past, then for the next 10 years, they would have to go get pre-approval before their lines are drawn. So only a jurisdiction who has violated a Voting Rights Act provision would be the ones that would be required to get pre-approval for their lines. So not every town, but every town that has violated a voting rights procedure. And this is what the National Voting Rights Act had before I believe it was the Shelby versus Holder case, where it struck down the pre-clearance provision for the states that were required to go to court to get their lines reviewed because they have past history of discrimination. So this is just making sure that if a city or town has violated a voting rights provision, they have to go before the court to get their lines approved because of that violation previously, only for the 10 years after the violation occurred.
Okay, thank you. so the protected classes is defined in here as a number of factors. Race certainly is one of them. Using that defining characteristic of a protected class to make a decision about lines, is that okay or not okay?
All right, so I want to make sure I understand so you're talking about the definition of protected class on page 2?
Yeah, so I'm just talking about each protected class that's named there has a particular characteristic. Sometimes race, it looks like religion, there's several listed there. But if I use that, or not me, but if one uses that defining characteristic of a protected class to make a decision about the lines, is that inappropriate in your opinion?
So looking at the definition of protected class, we're talking about race, color, or language minority. And so I think when lines are drawn, they should take that into account, is what we're saying.
Okay. But if somebody takes it into account, if a particular commission that draws a line takes it into account in a way that you feel that you're not comfortable with, then that wouldn't be okay.
Right, it would give whoever's not okay the ability to go to court and say, this is not okay, and let the court decide.
Okay. Yeah, I appreciate you indulging that question. The reason I bring that up is because I think either way, we're saying that using that particular factor of that protected class to make a decision, it's not okay if the outcome is one thing, but it's okay if it's obviously if somebody specifically say this, if somebody draws a line specifically because they're trying to separate somebody or trying because of racial reasons, because they have but it could be for any number of reasons. So I think my concern here is that we're separating and balkanizing and putting people into groups here. And that I think just this is reinforcing that. I think and I'm not saying the entire, some of the things that are in here are fine and I could support, but not as it's currently written. I just think philosophically, the current court case went to the Supreme Court showed how complex it is. There's too much subjectivity, and I don't know who's going to be looking at this in the future, and that makes me nervous because they could be making a decision based on mostly political reasons versus actual facts and objective facts of the case. So, thank you for answering my questions.
My
Brad.
pleasure. And I
appreciate
think, one of the main points of this is to give people the ability to, if they identify a potential issue, to go to court. And that is another thing that the Eighth Circuit in the Midwest has struck down, the ability for a citizen or a group to go to court and say, we've been wronged or I have been wronged. Right now in the Eighth Circuit, you can only be done by the U.S. Attorney General. And so we want to make sure that folks, individuals, groups, entities have the ability to, when they deem a potential issue, to be able to go to court and have a court look at this issue or look at the potential issue.
So based on your understanding of existing Rhode Island state law, without this in the mix, if somebody felt like the lines were drawn inappropriately intentionally to split groups based on a protected class, because let's face it, we know what happens for political reasons now, you would say they had no recourse in Rhode Island?
Not
based
in
on
Rhode
state
Island.
law?
I think that Eighth Circuit decision only affects the Eighth Circuit.
Yeah.
But the way that things have been going the last 10 years, we don't know what the future is going to hold. So I think any court case that's created from Rhode Island now is probably leaning on the National Voting Rights Act. We just don't know we've seen that be diminished year after year after year. So we're trying to protect Rhode Islanders' ability to go to court and to say, hey, this is a potential issue, and have the court decide.
Okay.
So if we were in Minnesota or South Dakota or North Dakota or Missouri or Arkansas, I think those are the states in the 8th District, they could not do this because that court has deemed only the U.S. Attorney General can bring a suit based on Section 5 of the Voting Rights Act.
Okay. Makes sense. Thank you. Appreciate it.
Go ahead.
So just to piggyback off the commissioner's question. So you're not contending that the First Circuit has ruled on this, right? There's no issue in the First Circuit at this point in time, correct?
Correct.
Okay, so there is a remedy right now to go to the First Circuit.
I believe based on the National Voting Rights Act. And so I guess the fear is that as we continue to go down this path that we've gone down the last several years, there may not be recourse in the future. And we're trying to just make sure that we're protecting our voters.
So walk me through the enforcement part of this. because I have some concerns on the enforcement part. So walk me through, the group decides that there's been a violation of this particular statute. If it's passed, what happens?
So I'm going to bring my friend John Marion up to help with this. I know John has done quite a bit of work on this as well.
Phoning a friend.
Yes.
Hi, John, thank you.
Hi, thank you. And I'm happy to do the best I can. Again, not an attorney. This was drafted off of a model bill that was, written by NAACP Legal Defense Fund, Campaign Legal Center, and other national voting rights groups. To Board Member Jack Boney's point, it is a complicated area of law, and that's why we turn to national experts to help draft it. So to Rob's point, there is a circuit split, and so people who predict things that are going to get to the Supreme Court think that will get to the Supreme Court next term because there's a circuit split, and this court would likely rule that there's no private right of action under the Federal Voting Rights Act, which is one of the reasons why we thought something like this was necessary. But also, because of that decision last week, Calais, it's, the vote dilution portion of Section 2 of the federal VRA is largely unenforceable, right? Even if there is a private right of action, based on the Supreme Court's interpretation of how you have to prove a claim under the vote dilution section, it's an impossible standard. You have to prove racial animus in the intent of the people drawing the district lines, which in 1982, the U.S. Senate, so the factors that Mr. Jack Boney was asking about, those come from the U.S. Senate. So in 1982, when the U.S. Senate renewed the Voting Rights Act because it sunsets, they put in the Senate report a series of factors because they were trying to reverse a 1980 decision, a federal decision that had said you had to prove intent. And so the U.S. Senate and Congress adopted a standard that was not based on intent. It was based on disparate impact. And so you don't, under the federal VRA, until last Wednesday, was it? To be successful, you didn't have to prove that someone was trying to discriminate. You just had to prove that they discriminated in practice.
Just that this is the practice.
And now we're back to pre-1982, which is you have to prove intent, which is basically virtually impossible because what they can do is just say, well, we were partisan gerrymandering. And then they get out of jail free card because 2019, the Supreme Court, in a case that Common Cause Common Cause v. Rucho, they said that partisan gerrymandering is non-justiciable by federal courts. Doesn't answer your question, but so this is enforceable through the private right of action or an action of the Attorney General.
Correct. And what I'm asking is, walk me through.
Yep.
There's a violation or a perceived violation. Walk me through what happens.
Yeah, so there's actually two options in this bill. There is a non-litigation option, which doesn't exist in the federal VRA. That is done to be kind of cheaper for jurisdictions. So you could send a notice letter to the jurisdiction and say, we think there's been a violation. Here's our evidence.
And you ask them to cure it.
Yeah, and you ask them to cure it. They have, I think it's 60 days to cure it.
I saw that. In the event that the jurisdiction doesn't cure it is my concern.
Yep, then you would file suit after the 60 days.
And where is that suit being filed?
Superior Court.
Okay.
And then the court would evaluate based under the factors, whether it was vote suppression or vote dilution, they would weigh the evidence.
And so how would that affect, and maybe my question's better directed to our legal counsel. How is that going to affect the federal offices? How would the state court be able to determine that? Let's say the gerrymandering or the violation involved the 2 congressional seats or the Senate seats. And now, we get a group and they bring an action in the Providence Superior Court?
I'd have to,
And
I
again,
could
I'm-
not give you
I'm
a full
asking because
answer
this is what's
without
going through
looking
my head.
into that, in detail. I couldn't. It is complicated. I admit, it clearly is complicated. But the proper jurisdiction or the forum would be the Superior Court for any actions that are based upon this statute.
Yeah, so my concern in that issue would be, frankly, I don't think the Superior Court would have jurisdiction if it's a federal case. At least that's what my initial view of it would be. And I think that anybody who filed there would then be removed out to the federal court. But I don't know that for a fact because I don't know the mechanism here. But if I could just ask a couple of other questions.
Can I, on that, just, it's going to be moot because we're only going to have one congressional district after the next census,
And
in all
okay.
likelihood.
we're going
Just-
to have 2 senators.
But there's no district lines for 2 senators. Yeah.
And you say we're going to have 1, we're going to have 1. So at some point, we may have 2 again. I
Yeah.
don't know.
Yep.
Hopefully, Rhode Island can get more people to stay.
I worked hard to retain that second district last time. I'll work hard this time, but the odds are against us.
Okay.
We're not growing.
So I guess some of the things that I have concerns with, we talk about in subparagraph, well, let me just get to the right page. On page 4, it looks like. Well, let's go on page 3, first of all, on line 13. A material disparity. Is there anywhere in here that a material disparity is defined? Or is that something that the court's going to have to decide?
I don't believe it's in the definitions section, so the courts would have to decide.
And then we look down to line 18, a totality of circumstances, which is also something that's going to be litigated, I'm guessing. I have some concerns with that. I have the same concerns that Commissioner Giacofoni had with the circumstantial evidence portion of this. But then when we get to the enforcement, I guess if a private party or private entity brings this lawsuit, they're entitled to legal fees, are they not, and costs?
Yes.
Okay. And that's very similar to what's going on with the Open Meetings Act. And the Open Meetings Act provides for attorney's fees and costs. And frankly, it's been somewhat abused, at least from my experience, anyway.
Yeah.
But I guess my point is, you have costs there, but the cities or towns wouldn't be able to recover costs if they prevail.
Yeah.
So
Yeah.
someone brings an action,
Yep.
they fail. Now, the city or towns expended a lot of time, man hours, and costs associated with defending the case. Because as we all said, these are going to be complex cases. There's nothing in the statute that, in fact, they're not permitted to collect costs or fees. And I understand that might chill a suit. But to have not even the ability for a court to make that determination as to whether or not the suit is so frivolous that there should be legal fees under the statute, I think is problematic. But that's just for me. So I've got some issues with the definitions, and I've got some issues with this in practice. Have any of the 8 states that you guys know of, that anybody knows of, have there been any actions brought under those their voting rights?
Yeah, there've been a handful. I think the city of Newburgh, New York,
Okay.
New York recently passed a VRA 3 years ago, I think, and there's been 1 or 2 suits in New York. There've been a handful. I don't know if you have more exact
No
numbers.
more than a handful, yeah.
Okay.
And honestly, like under the federal VRA, there've been 3 suits since 1982 in Rhode Island, right? 1982's redistricting, the so-called Rocco's Robots,
Mhm.
Harold Metz's 2002 action and then the action brought by the Department of Justice against Pawtucket. So
Okay. Thank you.
Thank you. Anyone else? Commissioner Schultz?
Yeah, I was just saying, I'm reading this. There's nothing in here that prevents gerrymandering, right?
no, I would argue, so the vote dilution section.
Other than that, other than vote dilution and protected class, one could gerrymander based upon political.
Yeah, this
That's-
isn't designed to address partisan gerrymandering.
Correct. Yeah. And secondly, there's nothing in here to provide guidance to the General Assembly or local cities and towns on how to create voting districts.
I mean, no, but that wasn't what it was designed to do. The
Right.
Federal Voting Rights Act never said you must design districts that way. That's determined, so until last week, it was a case called Gingles from 1986. And, states and municipalities had to follow the Gingles standard. And race is a factor, but it can't be the only factor that is considered when following the Gingles standard. So until last week, every city and town in the state of Rhode Island had to follow the Gingles test, it was called, when redistricting. But now they don't. They have to follow the Calais test.
And you see what's happened nationwide, where states are redrawing their maps and in less than a 10-year period. So is there anything in here that will prohibit redrawing maps in less than a 10-year period?
No, I believe we would have to amend the Rhode Island Constitution to prevent that.
But this, in the Rhode Island Constitution, once you draw the maps, can it be redrawn in a period less than 10 years?
I have not looked at the Constitution and examined it for that question.
Yeah.
I don't think so, because we did in 83, we redrew the Senate as a result of that 82 lawsuit against
Yeah.
Majority Leader Quattrochi.
So what's happening nationwide is, I think, reprehensible. That, when some states are going to withdraw the maps because they want to create districts that appeal to one particular voting block, rather than stay the 10-year period. I just want to make sure the Rhode Island, we have that 10-year period in there.
Yeah, I don't think we can do that through legislation, and that wasn't what this was aimed to do. Common Cause has introduced in separate legislation, not this year, a statute or a constitutional amendment to create an independent redistricting commission. And in that, it would ban partisan gerrymandering, but this isn't the device for banning partisan
I
gerrymandering.
understand that. I just want to
Yeah.
get sort of a handle what this bill does and does not do. The other thing is the hearings of Superior Court. Is there any language in there that there would be an expedited hearing? Or does the court take its normal slow walk in deciding cases?
Yeah, I don't believe, is there?
It is in here, yep. And if you give me a second, I will find it. So on page 7, lines 27 through and 28. Yeah, that's emergency. changing locations within city limits.
Yeah, page.
So page 14, starting on line 24. Actions brought pursuant to this chapter must be subject to expedited pretrial and trial proceedings and receive an automatic calendar preference.
That's very good. So we don't have any delays. Yeah. So I think the bill has great merit. So I'm going to support that legislation.
I have another question.
You mentioned there was three. You mentioned there was three suits brought in Rhode Island under the federal VRA. Could you just kind of give me a brief overview of those if possible? I just want to see that I know now under the Supreme Court decision, there's probably a significant need for this piece of legislation. So I want to get the lay of the land, as to where we've been in Rhode Island under the federal VRA.
Yeah, so your legal counsel may know more about some of these suits than I do, but in 1982, so redistricting happens after the census. The census always happens the year ending in 0. So redistricting usually happens in the year ending in 1 for the elections starting in the year ending in 2. So in 1981, 1982, Rhode Island redistricted, and some of these names may be familiar to you, but the majority leader, Rocco Quattrochi, had lines drawn for the Senate that he was trying to punish Richard Leach, who was a state senator, and Lila Sapensley, who was a state senator. And so on the east side of Providence, he drew a district that split Mount Hope, which is a historically Black neighborhood going back to like colonial times, and split it in half. And it wasn't done out of racial animus. It was done to punish people politically for being kind of dissident. Well, she was the Republican leader in the Senate, and he was a kind of liberal Democrat that wanted to be punished. And so split the Black neighborhood. And so they brought a federal court case under the VRA, and the settlement was to create new districts that reunited Mount Hope into a single district. So that was not intent. That was just, they were the collateral damage to going after your political enemies.
So let me
Yeah.
pause you there. So now, under the new Supreme Court decision, the intent wouldn't have been there. They would have allowed that to go through. This would be allowed to continue because there wasn't racial intent involved in that decision to split the neighborhood.
Yeah, and I won't profess, like, smart voting rights lawyers are still trying to figure out last week's decision, but yeah, I think
General.
at the highest level, that's true. Yeah.
Okay. All right. Thank you.
And then there was one in 2002, complicated by the fact that the Senate was downsizing from 50 members to 38 members. So it wasn't as exactly clear, but there was one Black senator, I think the first Black senator, Charles Walton, and his district was split. And Harold Metz, who eventually became the senator for the district that resulted, sued. And there was a settlement. Again, the Senate leader, Montalbano, who's now presiding Judge Montalbano, they settled the suit and redid the I think it was 6 districts in the Senate, and they united Mount Hope and Upper South Providence. So if you look at that Senate District 3 today, it kind of connects Mount Hope and Upper South Providence as a historically Black community. And Tierra Mack represents that district. So those were the 2 vote dilution cases that have been brought in Rhode Island. And then 2 years ago, the DOJ brought a case against Pawtucket under what's called Section 203 of the Voting Rights Act, which isn't about race, it's about language access, and alleged that Pawtucket hadn't provided proper language access to Pawtucket. They entered a consent order that goes through 2028, so it's still in effect. But as the secretary says, he's had lots of meetings with the DOJ and they haven't asked about that consent order once. So the DOJ is probably not enforcing that at the moment, and holding Pawtucket's feet to the fire. And there is a reference in Title 17 to Section 203, but I don't think it's enforceable the way this would be enforceable on communities.
Thank you.
I don't have much to add to what John just said. We were involved indirectly. We were a named party, but we were not directly involved in the Mets litigation back in 2002. That was in federal court, obviously. The Federal Voting Registration Act, or legislation, I should say, does call for a 3-member panel. I don't know if it still does, but there's a 3-member panel of judges. So that does help to keep it on an accelerated basis. But in that case, and I think it was the head of the Senate was William Irons at the time, not Montalbano. I believe that's who it was. But there was one Senate district that was split, and the claim was that there was a candidate who was just about in the last election able to, as a Latino representative, was able to win. He didn't, but the claim was that he was very close to doing so. And then as part of the redistricting, they cut that district right in half. And that really kind of created a competition between two minority groups, both Blacks and Latinos. So you have the rising population of Latinos, you have representation by people in the General Assembly who are Black, and there was a friction with that. But I think, to answer your question, if it's prior to Calais, you just have to look at the effect of the act. You do not have to look at the intent. So if the effect is to dilute this minority group that is rising in power, that was seeking representation, even if that wasn't the intent to discriminate, that would still be a cause of action. The way that Justice Alito interpreted the act this last week, and I do agree that it's going to require a lot of analysis, but it does seem that unless race is what the motivation was, there will be no cause of action that would be considered cognizable. So they would lose if you cannot prove that what motivated them was a racial bias. So in the 2002 case, I don't think that would even have legs. I don't think you could even bring it successfully because there was no intent. There was no intent to discriminate against Latinos, but that was the consequence. And that was settled. So there was no judicial outcome in that case. To my recollection, that was a settlement.
Yeah, and I'm sorry, you're right. I think the suit was brought under Irons, but he resigned before it was settled,
I
and it was
see.
settled
Okay.
by Montalbano. And then ironically, Montalbano lost under the new district lines because he took, I think, part of Lincoln.
Correct.
And then that O'Neill, as an independent, beat him.
I was on the board of canvassers.
Okay,
back
so,
then,
ironically, he, kind of took one for the team and took the bad district in order to settle the lawsuit, and then it led to his losing re-election. But that has nothing to do with what we're doing here.
Let me circle back to the mention of a 10-year judicial supervision if there was an issue. In a case like that, which, is it a city or a town that's going to be supervised for that next 10 years? Or like in this case, you're talking about the state legislature.
Yeah,
was
it would
involved
have
in
been the legislature. If they had to redraw the maps, they would have to go to the court. In this, and in both of those lawsuits, it was a federal court that approved the maps, it approved the settlement. So, it's somewhat similar in that the court was the one that ultimately gave its blessing to the maps. So this is, so the federal VRA, as Rob said, there's sections 4 and 5, which had a pre-clearance regime that was mostly the states, the southern states, but some jurisdictions up north and out west that had a history of discrimination. And they had to get pre-clearance from a federal court in DC or from the Department of Justice. 2013, Shelby versus Holder, Justice Roberts wrote an opinion that didn't say that was unconstitutional to have pre-clearance, just said that the map wasn't basically up to date. They weren't using current enough data. And so Congress, one party in Congress has been trying to update that map ever since, but they can't get past the filibuster in the Senate. So, it's somewhat complicated. There was a decision made not to put pre-clearance in this. New York's VRA has a pre-clearance regime, very similar to the federal VRA and some other states. That seemed a lot for a little state like Rhode Island that honestly only had 3 suits in the last 40 years. So didn't have this history of lawsuits that we could say, okay, these communities are subject to the pre-clearance requirement. So this is kind of pre-clearance light, but it's only triggered if somebody is found by a court to have engaged in, racial discrimination based on, or voting discrimination based on race.
Thank you.
Thanks, John. Anyone else? Yes?
Just, Rob, from your perspective, what type of regulations would the Secretary of State be involved in? under
Which
this?
section?
Looking at page 8, line 12.
Is this the language access? Yeah, so this is the language access portion of it. So we want to make sure that with our office, especially with the creation of the ballots and in most of our election materials, we already actually have them in English and Spanish. The only addition would be for the ballots. So we've got the 4 cities and towns that we do it for now. And if another city or town were to reach that 5% threshold, we would have to create the ballots in Spanish as well. But all of the other materials, voter registration forms by the Board of Elections, our declaration of candidacy form, all of our voter referenda guide is already in Spanish. And so we would just add that town to the list of towns that get that information. The board would include all the polling place signs have to be in English and Spanish for any additional town that meets that 5% or 3% threshold.
And then just for Ray, in looking through this, have you seen any particular problems with this legislation?
You've raised a number of questions, but no, when I read it, I did not envision this as being a barrier or a problem for us.
Anything else from you?
No, we appreciate.
Yeah, I
Yeah, go
did
ahead.
send a letter with
Yes,
some amendments.
I was gonna bring that
If you
up.
have any questions about the amendments, I'm happy to answer them, but, some are self-explanatory, like the implementation date, but others, require some explanation if you have any question. And while you're looking at that, I'm just going to thank you. So you may not be aware, Common Cause and the League of Women Voters held an event here on April 18th, where we were trying to kind of teach people how elections run. The Secretary of State's office had representation. Gianna from the Woonsocket Board of Canvassers came, and your staff rolled out the red carpet, and we had about 50 people in this room. The most enthusiastic response we've had to one of these events. After 2 hours, people wanted to linger. Like they gave them a tour of the facility, and people really, I think, find it fascinating how elections are run. And I just had people coming up to me afterwards saying, I had no idea. Like I had no idea what was involved, and I learned a lot. So thank you to your staff, particularly Joanna, for rolling out the red carpet for us.
Well, and thank you. That makes me happy to hear, John. Thank you. Any questions on the proposed amendments? And just to read this, what we have in front of us does not include this. That would be a sub A that you would, okay.
Question on the amendments. Does the Secretary of State's office have any comments on the amendments, opposition or support,
We support the amendments.
or all the amendments? Thank you.
I see folks are reading, so I'll give you a minute. You looking at me.
I mean, this stuff was just presented to us today, but other than clarification on the amendments, what are some of the substantive changes that you proposed?
Yeah, I think the first one is, in that definition of protected class, it includes things beyond race. Those other characteristics should not be in there, right? So race is, treated with strict scrutiny under Supreme Court precedent. Gender, religion is not treated subject to strict scrutiny, so that needs to be in a separate section. So that is, I think, the second amendment that we're proposing, is just having a standalone section that deals with discrimination based on those other disability, age, sex, sexual orientation, gender identity, change of marital status. So that needs to be standalone because that's subject to different scrutiny. And also those factors from the 1982 Senate report, those are all about race. Those are about proving the disparate impact based on race. So those aren't applicable. You can't, gerrymander people based on, sex, right? Like you'd have to split households in half. So that is a big one. Another big one is number 3, which is that some of the 1982 Senate factors aren't in the bill, and we'd like to get those back, get them into the bill. And then I think those are probably the most, and then I guess the number 9 in the remedies section. So obviously, like, remedies super important when dealing with some of these factors. We believe that the plaintiff should get a say in the remedies. It shouldn't just be the jurisdiction that got sued, and that outside groups could propose remedies. So maybe Common Cause wasn't a party to the suit, but we have an idea for. This is pretty common in federal litigation. So oftentimes federal judges solicit maps from third-party groups. My organization has submitted maps in states like New York that have been accepted by federal courts. Sometimes a third-party group has ideas for how to solve the problem.
Thanks, John. Great amendments. Anyone else? Thank you.
Thank you.
I
Commissioner?
have a question, a point of order. Are we going to vote on this to support the legislation or not?
I
this
would
position.
ask you the same question.
That's it.
I think we should if there is a motion to be made.
Yes, well, I plan to make that motion, then. Thank you.
Thank,
I move that we support the legislation embodied in 2026 8334, with the proposed amendments as provided by Common Cause to that specific act.
And a question for that, you on that motion, if, in the event that the legislation were to be passed or
Amended.
submitted and reviewed without those amendments, would that change your support of the legislation?
Well, maybe it's a question I should ask you. Should we
Well,
take
I'm
this
asking-
in sequence?
Well, you can do it in sequence, you can, or you can, it depends on the consensus of the board, but if the board were willing to support the legislation with or without the amendments, you could make that your vote. So either way, it would be accepted, with or without the amendments. If you would only do it with the amendments, then you should take separate votes, separate motions.
Then I move that we support the legislation with and without the amendments.
Is that?
Either way,
both
you would
ba- that covers
support
both
the
bases.
passage of the legislation.
Yeah, that will cover both bases. correct?
Okay.
But we do know that the secretary's office supports the or agrees with the amendments, but you're saying in the event that
Well, in the
something
event that
changes
the-
between now and
In the event
and
that
then,
they were not to
Yeah.
make it out of,
Yeah.
are they, where does the status of them right now? Where does it stand?
So the bills have had their hearings in both the House and Senate, held for further study like all bills are after their first hearings. And we're awaiting, the creation of a sub-A and engaged in discussions with both sides about the creation of a sub-A. That we've submitted the amendments to both sides. There's no agreement on any sub-A at this point.
So it may pass through without the amendments
It
that we're looking
could,
at.
we would probably, we might oppose it. Common Cause might oppose it if we don't
Question. I
get some
see
of these amendments.
I see.
I didn't understand.
We expect we'll have the ability to engage them in, which amendments they can support.
So you would only want to see this advance with the amendments added in.
Yeah, I think there's some amendments we would be open to, negotiating, right? So, effective date and, things like that. There are, I think for the, for instance, like we've got to fix that flaw where we put those characteristics in the
Yeah.
definition of protected class, because otherwise that really kind of imperils the legislation. And so that we would have to say, come on, you have to fix this. So
Sorry,
then-
Ray, I see
yeah,
what you
sorry to
mean
make
now.
it-
I was confused.
That's not a
at
straight
so-
answer. So-
So really then perhaps you just want to take one motion with respect to the legislation with the amendments.
So then, what if only some of the amendments are then put in the sub-A? and
Well,
not all of
unless,
them?
unless you knew what they were, I don't know how you could take that vote.
That's what.
Yeah.
And then
But
I-
one thing on that, if it was a subset of the existent amendments, well, I would think that you still are expressing your support for the legislation because it includes each of those, just not
Mhm.
all of them.
And then I have one other question just on the phrasing in the agenda. Because looking at now agenda item 2, it says may hear proposed legislation, and it doesn't speak to a vote. Sorry. I was just reading it off.
I
the
know,
top of
I
the agenda. I didn't even notice it off our written agenda. I didn't notice it until I looked up there.
Yeah, it should, if you are going to take a vote, we usually have the action item to vote used in the agenda. So we should, I mean, everybody who's had notice.
But
knows
isn't that a
exactly what-
material change though, right to the agenda?
The
The difference between here, because some member of the public may not have cared that we were hearing it.
Yeah.
They may care that we're voting on it.
I can't argue with that.
So we need another meeting, is what you're saying?
I don't know.
I
Well,
will
yeah,
say that, I mean, that has come up more recently in terms of the language, to put the language in there to vote, that the board has in the past voted on items that have not specifically included that language. I mean, prior to my tenure, but, I know we have made attempts to put in their language when votes will be taken in the last few meetings, just to clarify. So that's in everything, pretty much. My thoughts are to put it into everything, just in case.
Yeah.
But again, a lot of this follows language that we have used in the past on past agendas, because we use our past agendas as guidance to how to word language for current agenda items. So it would be up to the board if, we are planning on having another meeting before our next regularly scheduled meeting, because the rules and regulations for early voting will be presented to the board probably within the next 2 weeks. So that'll be before our regular June scheduled meeting. Just not sure of the date, but it'll be the week of Memorial Day. So it could potentially be put on that meeting, and we could also perhaps get a sub-A ready at that. If there was a sub-A, that would be ready at that point too. So it may make more sense to wait to see if there is a sub-A,
Okay.
regardless.
Okay, two things, Ray. What do you suggest? And then the other is, how does this affect, what are you hearing about the timeline with that? I don't want to jam you guys up either.
I think the sooner we could get support, the better, certainly understanding the challenge. And I think just, our office would, we will not, this is our bill, it's our top priority. So we hope that the board would support either with or without the amendments. Certainly, we agree with the amendments, but we think it's important that we move in a direction that protects our voters. So from that respect, we hope that the board would support with or without the amendments. But I think that the sooner the better. I know that probably doesn't help you, but we know that with the end of the legislative session coming within like a month, I think it's important that, we have the board's support. So
Yeah. Yeah, no,
We
I think
appreciate
I think it's important. I'd be willing to have another meeting sooner in order to get it done. But Ray, what do you
I
suggest?
think that's, at this point, I think that's prudent. I mean, given the discussion we've had, it would be advisable just to make sure that the vote is taken with an agenda item that mentions the word vote. So we should do that.
Okay. So can you,
On the other hand,
ahead, David.
can we take a vote on the consensus?
Pardon me?
Can we take a vote on the consensus of the board as to passage of this legislation rather than voting to support it?
Well, I'm not sure what you're saying. Take a
Well, you can
vote.
say the consensus of the majority of the board is in favor of the legislation.
Yeah,
Without
I mean,
actually having a vote in favor
well,
of it.
yeah, but that's not, yeah, I mean,
it's like a temporary.
a consensus of a public body constitutes a vote. So if you were to express if a public body were to take an action based upon a quote consensus, either by circulating emails amongst themselves or whatever else, but never take a formal vote, that still would be considered a vote in violation of the Open Meetings Act.
Okay. Okay, so let's just move to get something on the calendar for next week if we can, this week.
We can certainly do that. I was planning on, as I said, having a meeting the week of the 23rd. But if you want to have it sooner than that, then I certainly can make those arrangements.
I mean, I defer to the board, but I think we should have it sooner. We've spent a lot of time today, so let's just, that's my
Business
preference.
for the week of the 23rd, can we do it sooner?
23rd
or
is
is there a
Friday.
reason why it
Well,
needs to be-
Memorial Day, the week of Memorial Day, so obviously not that Tuesday.
Yeah.
The Wednesday or Thursday after Memorial Day was the plan, but we can
That would be
certainly,
the 27th or 28th.
yes, correct.
But that particular business, we won't be ready if we did it next week, say, for example.
Why not?
We could be potentially, that I could certainly move it up to.
With the other business that,
Yes.
yeah. I think we should try to do that. I'm gonna press on this because
That's no problem from our perspective. No.
okay. All right, so we'll connect.
Yep,
On this, okay.
absolutely.
So we can move on. Yes,
Okay.
yes.
I would respectfully remind the chair or inform the chair that I would be away from the 14th to the 22nd.
That's very sad. Thank you, sir. Thank you. But you are here
I'm here until the 14th.
until the
and I'm here-
14th.
I'm here on Memorial Day too. so.
Okay. Thank you. Moving on, agenda item number 3, the board may receive a report from campaign finance concerning candidates referred to the Rhode Island Department of Revenue Central Collections Unit, CCU, for collection of late filing fines and fees assessed to them pursuant to Rhode Island General Laws 17-25-11 subsection G, subsection 2, 3, and 410-RICR-10-00-14. Hi, Rick.
Good afternoon. There are 2 slides that I will direct you to. What I've got before you is some graphics that would show the board's history so far with the Department of Revenue Central Collections Unit. In 2019, the board entered into a contract or memorandum of understanding with the Central Collections Unit to help free up staff resources. So the staff was not getting so bogged down in doing collection matters, as well as the Central Collections Unit has deeper resources and ability, a larger staff to make collections. It was also keeping in mind that at the time, we were working on a regulation to handle the disproportionate debt that had accrued to some of the candidates for their late filing fines. So in 2025, that regulation was adopted, and it has been utilized by the board to take some of the disproportionate debt, bring it down to a collectible amount, and in many cases, refer it over to the Central Collections Unit. So before you, I broke down the table by year. Again, 2019 being the first year when we had the agreement with the Central Collections Unit, some of the cases that were sent over there. And again, I broke this down by year. As you go through this, as you get to the end of 2025, I marked the cases with an asterisk that were part of that accounts receivable reduction regulation. And again, if you move to the second slide for 2026, you will see again, all of them are as a result of the matters that came before the board and the debt being reduced pursuant to that regulation. There are about 3 more cases that are in the pipeline that the board has voted on. They just have not gone through the 90-day payment period and then the 20-day notice required by CCU. Again, we feel that the program has been very successful. In total, there are 54 candidates that have been referred over to Central Collections. A little over $268,000 in debt was referred, and to date, they've collected a little over $41,000. But again, it's somewhat misleading because most of the cases have been referred late 2025 and into 2026. Our memorandum of understanding with the CCU expires December 31st, 2026. And again, this is not up for vote, but I'm hoping we can continue this relationship with them. It has been very effective for us. And any questions you have, I'm gladly entertain.
Okay, I just have one question. Of all these debts that were referred to CCU, how many have actually been prosecuted in the courts? You know?
There was one that has gone before the court, and there was a settlement. Actually, it was the one on the first page, Kevin Malanzi, $9,000 was referred over. There was $4,500 was accepted as payment in full. Part of the MOU is if CCU can reach an agreement with the debtor to a lesser amount than was referred by the board, the board's executive director, in this case, Miguel, can can make an agreement or adjust the amount that was referred. And in this particular matter, Mr. Malanzi owed campaign finance reports. So part of the agreement in court was that he had to fully comply with his filings in order to receive that reduced amount.
Yeah, I noticed that on page 2, Donald Gould, that was referred to 20 grand,
Yes,
he paid 20,000.
that's correct.
He paid that in full. Was that a case filed against him, or did he pay voluntarily?
He paid voluntarily on that.
And then there was another one that, where was it? On David Carlin.
Yes.
Uh,
He has been paying monthly voluntarily.
And that's
as
been
well.
done voluntary
Yes.
too. So other than that one suit, the rest is just voluntary payments?
To date, yes, yes. And some of the things that CCU advantages that they have that we do not utilize, they can charge interest on the debt that's referred. They can file a civil suit in state court. They can intercept tax refunds. They can attach wages and other compensation, and they can garnish or seize or levy against real estate and property. And again, those are avenues that they have that certainly gives them leverage and collections that we don't utilize.
Have anyone from CCU advise you of any debt that should be written off as a bad debt?
Not at this time. Not at this time. Again, there were 3 cases, Malanzi being one, and then in 2019, there were 2 cases where the board did accept as payment in full an amount lesser than what was referred over there due to their financial circumstances.
Thank you.
Thanks, Rick. Any other questions for Rick?
Just thank you for this. Rick.
Thank you very much, yeah. For the next, Ray, do I read the next 2, since they're both executive sessions, so I'd read 4 and then 5?
Yeah, we'll have separate motions
Yeah.
for them, yes.
Okay. Agenda item number 4, the board may vote to meet in executive session pursuant to Rhode Island General Laws, 42-46-5, subsection A, subsection 4, and 17-25-5, subsection A, subsection 7, subsection I, to discuss and/or vote on a proposed consent order for violations of campaign finance laws in one campaign finance matter. Do I have a motion to meet in executive session?
Motion to meet in executive session as discussed by the chair.
Second.
Moved and seconded. All in favor signify by saying aye.
Aye.
Aye. Any opposed, abstentions? Motion passes. Agenda item number 5, the board may vote to convene an executive session regarding investigations into allegations of misconduct, either civil or criminal, in accordance with Rhode Island General Laws 42-46-5, subsection A, subsection 4. Do we have a motion to convene an executive session as outlined?
Motion to convene an executive session as outlined.
Moved and seconded. All in favor signify by saying aye. Aye. Any opposed, abstentions? Motion passes, and we will convene an executive session at 5:20 PM. Do we have a motion to seal the minutes of executive session and resume open session?
So move.
Moved and seconded. All in favor signify by saying aye.
Aye.
Aye. I don't think anyone's opposed. And Ray, we don't have,
We
do you
have,
have
we
your
have one
report?
matter
Yep.
to report
Okay,
out.
go ahead.
and that is a Campaign Finance Director Richard Thornton presented a consent order relating to Charmaine Webster for consideration by the board. After discussion, Board Member Scholes moved to approve the entry of the consent order, seconded by Board Member Jacoboni. All members who are present voted in favor, none were opposed. And that's it, Madam Chair.
Thank you, Council. Do we have, yes?
The referral vote, you don't need to report that. We did refer something.
Typically that would be done, since it's a continuation of an investigation, that would be something that would remain confidential until the full investigation has concluded.
Thank you. Do we have a motion to adjourn?
So moved.
Second.
Moved and seconded. All in favor signify by saying aye.
Aye.
And we are adjourned at 6:22